This is Paul. It's been raining most of the evening. Yes, all night. In fact, I had to use an umbrella. Oh, when you have to walk every place that you go, that car is a convenience, isn't it? Now, this morning, I'm having some difficulty understanding exactly why am I going to court. I looked at the actual date of the facts of Exhibit A. Yes, and it was June 3rd of 2017. Coach, did you get that evidence before the crime happened? I know it's just a fax copy of a protection order. Yes, where it says the boxes are not X'd. Yes, that I did not receive notice of court hearings, as if that were a requirement of law. This morning I'm not really that happy because I didn't get any phone calls. My sons didn't call me. Marilyn didn't call me. No one called me. I made some recordings and I put them on my drive, as if those on Facebook were curious to know what I had to say. Now, we seem to be having some problems with the actual enforcement of due process. Over the last week or so, I explained the penalty of perjury, and then yesterday I showed you what the penalty of perjury says, true and correct to the best of my ability. That was the state of Washington's articles of incorporation, and then there's the certificate of the limited liability company. But you decided you're going to continue to enforce your court orders where I did not receive actual notice or the opportunity to be heard before you issued your dissolution of marriage or your protection orders, as if me, right, the alleged perpetrator of the crime of domestic violence, right, that had been arrested on Guam. I'd never been arrested in Washington State. And my record was expunged. I don't have an arrest record or a criminal record. I'd never been convicted of any crimes, and I'm going to go to trial on the 30th, 2 days from now, and you're going to say that I need to be restored to sanity. Pooch. Now, that evidence that was admitted into the court, yes, Exhibit A and Exhibit B, yeah. I would think that the facts, day and time has to be correct for it to be actual evidence. But I realized it was July 3rd of 2018 that my attorney had signed the motion to dismiss one of the counts. Yes. Now, does that start the speedy trial process? Because that was 5 months ago. Can you actually motion a court for dismissal of any of the criminal complaints that you use sovereign power to have me arraigned for? Yes. And not consider the admitting of the motion to dismiss as the start of the trial to dismiss one of the charges so that we would only have to have a jury trial. Now, you're making me go to court when it was 5 months ago that somebody did respond to the motion to dismiss prosecuting attorney's office 5 months ago and said, well, I have in my possession an actual email that pooch. Now, I'm just wondering, when you admit, right, evidence and a motion to dismiss, doesn't that start the actual speedy trial? I think it does. Now, why is it that you're having... Well, I have the legal right to a speedy trial, and you motion the court to dismiss one of the criminal complaints, and you used a fax that had the date and time right now.